Morning, everybody who's joining us. I should do some introductions first. I'm a principal associate in the education team, and I will just be chairing today, hoping that there may be some time for questions at the end. Our speakers today are Catherine Savage, who's a partner in our education team and specialises in all types of academic litigation with a particular focus on the complex student claims and complaints, of which we know there are a lot. Gavin is a senior, soon to be principal associate in our public law and education team, again, based in the Birmingham office. And he deals also with all types of regulatory and student matters and predominantly student complaints and disputes. So they will be speaking today. After the session has finished, you will be sent a recording and all of the slides. If you want to post questions during the talk, then please use the Q&A button. That's anonymous, so we don't know who's posted and it won't be seen who it's come from. But if you do want us to follow up afterwards, if we haven't got to your question, then do leave your name and contact details and we can get back to you afterwards. I think that's probably about it. We will have a feedback form at the end, so please do fill that out if you have a chance afterwards. And yeah, I think without more ado, I will hand over to Kat.
Thank you, Kate. Good morning, everyone, and thank you for attending. As you know, we're here this morning to talk about everybody's favourite topic of student litigation. Fully appreciate that this is quite a broad spectrum in terms of a topic. So the way we're going to approach it is we've considered the claims that we most commonly see in this context, and Gavin's going to kick us off by looking at student claims in the context of COVID and strike interruption. And then I'm going to take over and look at the other really common area for disputes, which is around the Equality Act claims. And we see a lot of those in kind of the student litigation context. And then between us, we're going to conclude by saying a bit about alternative processes like the OIA, ADR, mediation. And then we'll finish up by providing some common sense tips for dealing with claims once they land. So I'm going to pass over to Gavin to talk about COVID and strike interruption claims.
Thank you, Kat. Right, so one of the big issues facing the HE sector at the moment is student claims arising from disruption to studies, whether that be due to the COVID-19 pandemic, as Kat says, strike action, or other circumstances outside the control of institutions. As you all know, the pandemic resulted in substantial restrictions to in-person learning and access to facilities. And not long afterwards, the university and college union staged a national marking and assessment boycott, which delayed graduations, job starts, and transitions to postgraduate study. Since then, there's been further lecturer strikes driven by disputes over pay, working conditions, and pensions, with more being announced on an almost weekly basis at the moment. These circumstances have given rise to various claims made by students against their universities. There is, of course, the group legal action being brought by thousands of students and graduates against UCL and other institutions over claims that education was affected both by the pandemic and the UCU strikes. As everyone's probably aware, the students asked for a group litigation order to try and bunch those claims together, but that was actually refused by the courts last year. And instead, the UCL claim will serve as a test case for all of the other claims, which have now been stayed pending the outcome of a trial in that UCL claim listed for early next year. There are also an increasing number of claims being brought by students on an individual basis based around similar issues. Now, the legal basis for a claim arising from industrial action or other disruption to studies is, in almost all circumstances, breach of contract. That is certainly the case in the UCL claim. And the argument is that essentially in law, the students are consumers who have contracted with the university on standard terms for the provision of in-person tuition and access to campus facilities, and who paid substantial tuition fees for those services. There's also an implied term in the student contract that the services would be provided with reasonable skill and care. And the students say that they didn't receive the service for which they contracted and paid, and/or the services weren't provided with reasonable skill and care, which is an alleged breach of contract. So against that backdrop, the Office for Students, the OFS, decided to commission research into the impact of industrial action from a student perspective. It has very recently published a note which sets out the results of that research, along with guidance for institutions, which they've called Protecting the Interests of Students During Industrial Action. The stated aim of the note is to create greater regulatory clarity, ultimately leading to a more consistent approach across the sector and better protection for students. And I've provided a link in the slides to that note if you haven't seen it already, which you'll be able to access via the slides, which will be circulated after this session. Now, the guidance sets out 6 expectations for providers before, during, and after the industrial action. And that's intended to ensure students' interests are protected and make sure their education is delivered wherever possible. Those 6 expectations are as follows. First is to ensure providers' contracts do not include terms that incorrectly limit liability to students during periods of action by their staff or in other circumstances that could be within the provider's control. Providers are expected to remove any such limitations from their student contracts and should not rely on these limitations as a justification for failing to deliver services during periods of industrial action. Amongst other things, this will presumably include the removal of industrial action from force majeure clauses in student contracts. The second expectation is to develop effective contingency plans to minimise disruption to students during periods of industrial action. This could include rescheduling classes where possible, moving classes online, providing materials relating to cancelled lectures or seminars, or covering missed subject matter in other lectures or seminars. Thirdly, institutions should prioritise the delivery of education when implementing those contingency plans to try and avoid or mitigate the impact on the students' education. Fourthly, institutions are expected to pay fair compensation to affected students. The primary aim of this expectation appears to be to achieve some form of consistency across the sector in relation to compensation payments. And we'll come back to this expectation in a little more detail shortly. Next is to communicate clearly with students and ensure timely support is provided so that they are not left to navigate disruptions alone. This expectation includes something where the providers should apparently proactively identify those eligible for compensation to avoid the need for students themselves to submit claims. Students should also be made aware that accepting a refund or compensation payment does not limit their rights to use providers' internal complaints process. And they should also be told about their right to escalate complaints to the OIA. Finally, there's an expectation to submit reportable events about industrial action in accordance with the OFS's regulatory requirements. So there's a couple of key points to note from this guidance. Going back to the payment of compensation, the guidance says that compensation should be payable, quote, where contingency plans fail to deliver teaching, assessment, or other promised aspects of students' experience, or to recognise the difficulties students have experienced. What this seems to suggest is if an institution can demonstrate that a student's experience was not in fact disrupted, maybe due to the success of contingency plans, for example, then compensation would not be payable. And this is something that we've recently successfully argued on behalf of the university in a claim brought in the High Court by a student. We argued in defence that it cannot be said that the only way to provide the student contract is in exact accordance with classes timetabled, or the only way to act with reasonable care and skill is to somehow prevent industrial action from happening. The claim was dismissed and costs were awarded in favour of our university client. Although every case will turn on its specific facts, what this appears to demonstrate is that if a university that is the subject of a claim can persuade the court that its performance of the student contract was not something fundamentally different to that what was identified in the contract, then that will very likely form the basis of a successful defence. And really, the overall message from this is clear that the best way to try and avoid legal claims, or at least for institutions to put themselves in the best possible position to defend themselves, is to make sure they have robust contingency plans in place and that those plans are properly followed. Back to compensation, the guidance notably fails to differentiate between compensation paid for breach of contract and goodwill payments, where no breach is accepted by providers. Certainly, I would say that it's very unlikely that any institution would want to admit that it has breached the student contract, particularly without any specific compulsion to do so, whether by the OIA, the court, or otherwise. And we would certainly not advise that institutions do this unless there is, of course, a very good reason to do so. The next issue is the extremely vague suggestion that institutions should proactively identify those eligible for compensation to avoid the need for those students to submit claims themselves. This, to me, sounds extremely optimistic. Does the OFS genuinely expect institutions to go out and voluntarily start handing out money to students who haven't even raised disruption as an issue, particularly in these current times where finances are so strained? This seems very unlikely to me. And this takes us on to the final point, which is enforcement. The OFS has said in its note that it expects to continue to refer any potentially unfair terms it identifies in student contracts to national trading standards. Aside from that, there's no indication at all in the notes that these expectations are rooted in its regulatory framework via conditions of registration, or that any failings would lead to any regulatory action being taken against institutions. This presumably means there isn't really a great deal of incentive for institutions to feel the need to follow these recommendations or these expectations to the letter. However, what it might do is might indicate a kind of first shot across the bows from the OFS and provides like an indication of the future direction of travel where this might be going. So that's it for me on disruption studies cases. I'm now going to hand back to Kat, who's going to talk about disability discrimination claims.
Yeah, thank you, Gavin. So I'm now going to talk about another really common area for student claims, which are those that arise under the Equality Act. And the first of those is something that we see in student litigation time and time again, and that is claims involving an alleged failure by a university to make reasonable adjustments, i.e. to make adjustments to practices to avoid disabled students from encountering a substantial disadvantage when compared to their non-disabled peers. Many people will be aware of the tragic case of Abrahart, so I won't go through its facts now, but by way of a reminder of the impact of that case and the conclusions that the court drew from that, the court said that universities do not need to have formal knowledge of a disability before they're obliged to make reasonable adjustments. It said it's not enough for a university to simply tell a student to speak to disability services and then not make adjustments if they fail to do so. The court said that if members of staff know or ought to know that a student may have a disability, then reasonable adjustments should be considered. And a university can have knowledge of a disability without a diagnosis because sometimes it's apparent from the things that the student themselves says or does. So how are these claims best avoided, given how commonly we see them? Well, I'm afraid to say that the best way of avoiding them, of preventing them, is to try and avoid them in the first place, which is easier said than done because the obligation on universities, particularly post Abrahart, is quite onerous. And if you look at the EHRC's guidance that they produced after that case, it contains a whole long list of duties that it imposes on universities that are quite onerous. And they include that universities must ensure academic staff, administrative staff with student-facing roles, accommodation and support staff, staff dealing with appeals and fitness to practice processes are trained on duties under the Equality Act. and trained to recognise symptoms of mental health crises. It says that universities must ensure that a list of common reasonable adjustments is available to academic staff as well as disability services, and that reasonable adjustment policies are updated so staff know what to do if students are presenting with a possible disability but haven't engaged with disability services. So you see, that's quite an obligation on staff members. And on a related topic, a fairly common response we receive from clients when a student pursues a claim on the basis that a reasonable adjustment has not been made is, well, we weren't obliged to make that adjustment because we were being asked to adjust a competence standard. Well, it's correct to say that a university is not under any obligation to make a reasonable adjustment to a competence standard, that being the academic standard applied to determine if someone has a particular level of ability. But it can be hard to tell if something is a competence standard versus a method of assessment. And you may have seen that the Disabled Student Commitment published some quite useful guidance, its competence standard guidance last month. And even if your institution hasn't signed up to that commitment, it might be worth reviewing. I won't go through it in any detail, but what it does make clear is that those designing programs of study, course content, and assessment must identify, determine, and review competence standards. The guidance also says that providers have an obligation under consumer law to ensure that pre-course information covers details of any competence standards that apply to them. So, in reality, unless competence standards are written down in course materials, they ensure a lawful objective and are proportionate in terms of the aim outweighing any potential discriminatory effect, it will be really hard and difficult to rely on something as being a competence standard that doesn't need to be adjusted under the Equality Act. Another thorny topic in the area of student litigation is the extent to which universities owe a duty of care to their students. And this was debated in Abrahart, but ultimately has been left unresolved. And there's a case that's going through the court at the moment that may provide some guidance on this, which is the case of Jacob Meager and the University of Cambridge. In that case, the High Court has ruled that a failure to take reasonable steps to implement recommendations made by the disability support team could, in theory at least, amount to a breach of contract or a breach of a duty of care. Now, given the high volume of disability discrimination claims that seem to revolve around faculties not implementing recommendations that are made in support plans either completely or as intended, I could see this becoming quite problematic, because who will monitor the implementation of support plans? And will we see disability teams needing to be more specific? Are they likely to be more cautious? Will faculties and disability teams have to engage more over this process? And will that increase the time it takes to turn these plans around? And will we see the 6-month limitation period under the Equality Act being extended to 6 years under contract or negligence, kind of via the back door? So you could see that this could cause some difficulties, and it will be interesting to see how that case plays out. Another developing area is around claims that are brought against individual staff members, which the Meager case has also provided some guidance on. And we see quite often in Equality Act claims that individuals might be tagged on as defendants alongside their university employer. In the Meager claim, he included 5 individual staff members alongside the university as named defendants in his claim, and those comprised academics and also the head of the Student Complaints Office. The claim against the individuals, though, was struck out by the court on the basis of the Jameel principle, which allows courts to strike out claims that are technically valid. So Mr. Meager had the right under the Equality Act to name individuals in his claim, but they're nonetheless considered an abuse of the court's process due to the disproportionate costs and burden that are imposed on the individuals by being named as defendants. Now, this is the first time the Jamil principle has been applied in an Equality Act case, and as ever, the decision does turn on its own facts, but certainly worth bearing it in mind when you have a scenario where individual staff members are named in a claim for acts where they have carried those acts out in the course of their employment, and their employer otherwise accepts that it is vicariously liable for those actions. So that was just a whistle-stop tour through some of the kind of common issues we're seeing in the Equality Act context of student claims. I'm going to hand back now to Gavin. He's going to talk about mediation and ADR. So over to you, Gavin.
Thanks, Kat. So one point that we thought it might be useful to briefly touch upon relates to the OIA's role in resolving student complaints and how that interrelates with the legal process and the obligation on parties to a dispute to engage in alternative dispute resolution, or ADR. There are a number of recognised forms of ADR. The two forms that are particularly relevant here for this conversation are mediation and ombudsman schemes. As you will all know, the OIA is the designated operator of the Student Complaints Ombudsman Scheme. It has also been approved by the Chartered Trading Standards Institute as the Consumer Alternative Dispute Resolution Body for higher education complaints. There's an expectation from the courts that legal proceedings will only be commenced if a student is dissatisfied following the outcome of a review into the student's complaint by the OIA. And furthermore, the OIA cannot consider complaints where the matter is or becomes a subject of court or tribunal proceedings which have not been stayed, adjourned, or put on hold. And it's for that reason that we would always recommend that universities attempt to direct students towards their internal complaints procedures and, if necessary, the OIA complaint scheme before they pursue legal proceedings in an attempt to avoid getting embroiled in litigation. And the use of internal dispute resolution processes was the subject of an important case from 2003 called Churchill and Merthyr Tydfil County Borough Council. Although it's not a higher education case, it represented a bit of a shift in the court's approach towards the use of ADR, and so is instructive in relation to all types of dispute. In short, the judge found that the claimant, Mr. Churchill, who had not used the defendant counsel's internal complaints process before commencing proceedings, had been unreasonable in not doing so. And perhaps more significantly, for the purposes of this conversation, the judge went on to state that the courts can make an order compelling the parties to a dispute to engage in ADR, in this case mediation, even where one or both of the parties were unwilling to do so. And the court also said it was empowered to order a stay of the proceedings to allow that to happen. So this is quite a helpful development because although all cases turn on their specific facts, as we've already said, it gives universities a potential means of compelling what can often be very determined and sometimes quite unreasonable student litigants to the negotiating table. I'm going to hand back to Kat now to quickly run through a few more practical tips when dealing with student litigation.
Yeah, thank you, Gavin. So just a few final kind of practical points to kind of wrap up the session. Most, if not all, institutions will have a professional indemnity insurance policy in place that might cover these types of claims. If that's the case, it's so important to ensure that insurers are notified as soon as there's a possibility that a matter could become litigious. Most of the time, that will be when you receive a letter of claim, but it could be earlier than that, particularly for students engaged in communication with an academic and they're threatening proceedings. So to protect your coverage, notify insurers as early as possible. Also promote the legal team internally. Make sure that if a claim form lands on a member of staff's desk, that they know that that claim form or legal documents need to be sent straight to the legal team. Response times are time critical, and we have seen institutions having default judgments entered against them when they fail to respond in time, and that just racks up costs where further applications have to follow. check your website to make sure that the address on that website is clear and that it's the address that you would want a claim form to be posted to. Student litigants will generally use that address to serve papers on. So it's important to check that wherever that post goes, it's frequently monitored and it will be forwarded on as quickly as possible. Another point, which I know will be really obvious, but is to ensure that staff know not to put anything in writing that they would not say to a student's face. Almost all student claims these days are accompanied by a DSAR. I've seen some really damaging things between staff members in emails, and it's really difficult to not disclose those pursuant to a DSAR, and that can set things really off on the wrong foot if you're dealing with a student who is thinking about bringing proceedings or has brought proceedings. If the worst happens and you're served with a claim and it makes absolutely no sense, or the particulars of claim are a 50-page incoherent document or a one-page overview, do think about using tactical applications like strikeout or summary judgment applications. Yes, you need to be careful with litigants in person, and those types of applications have to be kind of teed up correctly. But by and large, you rarely come away from that type of application in a worse position. And quite often you can come away with a cost order in your favour, which can then be used for the purposes of negotiation. And of course, if you are in doubt or have any kind of litigation queries or need to discuss anything with me or any of the team, then please get in touch with us. We're always happy to help. So that concludes our session. I think we have a couple of minutes spare. So I will hand back to Kate to see if we have any questions.
Thank you both so much for covering so much in such a short period of time. A lot of food for thought. One question that we've had relates to, it was a point that you made, Gavin, about the OFS expecting the institutions to pay fair compensation, but have they given any indication of what that might look like in their view?
Okay, well, the short answer is no, I think. And actually, the OFS guidance is deafeningly silent about what it considers to be a fair and reasonable compensation payment. In the absence of any kind of specific guidance, my recommendation would be to turn to what the OIA recommends about what it considers to be an appropriate payment for compensation in the case of distress and inconvenience. As you probably know, the OIA's developed 3 bands for compensation payments, which are moderate. I think that attracts compensation of up to £500, substantial levels of distress and inconvenience, which have payments of between £501 and £2,000, and then severe levels of distress and inconvenience, which I think are payments between £2,001 and £5,000. There's a bit of guidance on the OIA's website about what it says constitutes moderate, substantial, and severe. And obviously every case is going to turn on its specific facts. But I think it's probably very likely that in most cases of industrial action kind of complaints and claims that they're going to fall within the moderate band, which would mean compensation of no more than £500.
Yeah, thank you very much. We've got lots of questions actually now. I'm afraid we won't have time to cover them. I'll squeak in a quick one to Kat, I think, which is, do you find that the courts tend to give students a fair bit of leeway as litigants in person?
Yes and no. I think litigants in person have to be handled quite carefully, and generally it all comes down to communication. So it might look quite aggressive to go straight in with a strikeout application if you think a student claimant has failed to do something compliant with the rules. But if you've written to them really clearly in very clear language, provided all those, links to the relevant passages in the CPR, given them a chance to kind of correct whatever they've done wrong. If they fail to do that or fail to use that opportunity, then if you go ahead with an application, actually, by and large, a lot of judges can be quite sympathetic to an institution that is being put to the expense of defending a claim that isn't being pursued in the right way. So it all depends how you kind of prepare, I think, for an application and every piece of correspondence that I write to a litigant in person, I write with a view to this is going to end up on a court file and the court will look at this letter at some point. So I think it's about teeing it up correctly.
Fantastic. Thank you. And bang on. Oh, just over. So thank you both so much. Thank you all for coming and attending. We will have to end it there, obviously conscious of your time, but yeah, please do give us some feedback if you have the time. We will send around the recording when it's available, and I think Kat and Gavin will follow up on the questions that we couldn't get to. So thank you all.